SJC-12449, Miramar Park Association, and others v. Town of Dennis.
Mr. Corbo, good morning.
Good morning, Your Honors. My name is Greg Corbo. I represent the defendant, the Town of Dennis, in this appeal of a decision of the Superior Court to grant the plaintiff's summary judgment and to issue a permanent injunction requiring the town to provide nourishment to their private beach. The town's position is that the judgment of the Superior Court, as well as its permanent injunction, should be reversed for three primary reasons. First, that the court erred in finding that the plaintiffs have a right to relief pursuant to General Laws, Chapter 214, Section 7A, on the finding that the town violated a statute, the primary purpose of which is to protect the environment. Second, that the court erred in finding that the plaintiffs have a right to relief pursuant to Chapter 214, Section 7A, on the basis of a finding that the town's actions or inactions are causing or about to cause harm to the environment. And third, that the court's order, which requires and directs the town's exercise of discretion, conflicts with applicable statutes and regulations and interferes with the executive functions of the executive branch. If it will please the court, I will address each of these issues in turn. So just to frame the matter, the plaintiffs have brought this case pursuant to General Laws, Chapter 214, Section 7A. What that statute allows is for a group of residents of the Commonwealth to bring claims to prevent or remediate damage to the environment. And there are two predicates to bringing an action under that statute. First, that the defendant is violating a statute or regulation.
Can I ask you a question about that? So the regulation that the town allegedly violated had to do with building or fixing or renovating the jetty, is that right?
That's correct. So the regulation that we're talking about here, it's actually a performance standard, and it's in DEP's wetlands regulations at 310 CMR 10.27. And what the regulation says is that in issuing an order of conditions for certain coastal projects, those projects have to meet certain standards to protect the environment. And in this case, one of those standards is that if you are conducting a project to build a jetty that interferes with the migration of sand, then that jetty must either contain a sand bypass system or the applicant is required to periodically dredge to provide nourishment for downdrift or adjacent beaches.
Now let me ask you a question about that. Is there an order of conditions on the record anywhere? Does one even exist?
So that's one of the issues of concern to the town here, is that when this case was brought, it was brought on the basis of the town's 2014 dredging project violating the regulation. And there is much documentation in the record concerning the permitting that the dredging project went through. However, there was just merely a passing reference to the fact that the town extended and repaired the jetty in the 1990s. So what the record shows is that the jetty was built sometime in the early 1900s. No one knows who built the jetty, under what circumstances the jetty was built. It was certainly built before this regulation went into effect. There was then this passing reference to the fact that the jetty was repaired and extended in the 1990s. And it was on the basis of that passing reference that the Superior Court said that, well, notwithstanding the fact that the original jetty construction project did not trigger the requirements of the regulation, and notwithstanding the fact that the dredging project itself doesn't trigger the regulation, this 1990s project did trigger the regulation. And the problem is that that was never raised in the complaint. It wasn't raised in the motion for summary judgment, so we have no record. We have no order of conditions.
Right.
We have no application. We have no plans.
I went looking for that 1990 maintenance project, because I assume there are environmental documents on that, right? I mean, and it's not in the record. We don't have anything on it.
That's correct, Your Honor. I mean,
And by the way, the judge, and I don't mean to cut you off, I'm asking about the same thing, but the judge also says that when you do a maintenance project on a jetty, then you have an obligation to do something. But he doesn't cite anything but the existing regulation, which doesn't refer to maintenance or improvement project. Is there anything in the regs that say whenever you work on something like that? Because, I mean, this is a 1930s jetty. Is there anything in the regulations that say if you make any kinds of improvements? Because environmental regulations often have that language in it.
no, Your Honor, the regulation does not say that. So the regulation, as I said before, it's a performance standard. And so it starts off sort of with the premise that if you're conducting a project that is going to have certain impacts, then certain standards need to be met. And
But that applies to the project in the 90s, doesn't it?
yes, that's correct. And so the way that these regulations work is that an applicant is required to apply.
Can I just, Judge Bud's question, I just want to make sure, so it does apply to the 1990s maintenance project, or does it apply only to the original construction?
Well, the court found that it
I
applied.
understand
Yeah.
the court found, but we're not bound by their interpretation. I'm just trying to understand, what's your understanding of that, of the question Judge Bud just asked you?
That's right. So my understanding is that the regulation does not say that it applies to repairs. It applies to, it says, jetties transporting littoral drift material shall contain a sand bypass system. It also says that any groin, jetty, solid pier, or other solid fill structure which shall interfere with littoral drift, in addition to complying with 31027, shall be constructed as follows. So it doesn't anywhere here talk about repairs. And so a person doing a project would have to apply to the Conservation Commission, and the Conservation Commission would have to make a determination as to whether the project triggered this regulation, and if so, whether the project then triggers the further requirement of having to meet the performance standard.
So given all of that, if we don't have the order of conditions or the permit, any of the backup information on that, and if the judge below didn't have that information, how would it have been possible for the judge to have come to any conclusion?
It's our position that it's not possible, that was the error that the judge made, that, this was summary judgment. The judge was bound to consider the facts in the record and not to rely on speculation or unsupported assertions or conclusions, but he made a leap here, and he found that the 1990s project not only triggered the regulation, but that the town violated the regulation in connection with that project. And it's our position that it was error on both fronts. A, because there was not sufficient information to conclude that project triggered this regulation, and B, insufficient information to conclude that even if it did apply, that the town violated the regulation.
Is there any debate about the 2014 project as to whether or not it complied with the regulation as far as nourishment of adjacent beaches?
So, no, I mean,
I guess the question I'm asking is the public beach here an adjacent beach?
in connection with the 2014.
You have to go past the river to get there. Does that make it adjacent or not? I'm not really clear on that. I think I know what downdrift means, and it's not downdrift, but is it adjacent?
Sure. So the beach that was nourished in connection with the 2014 dredge project is not downdrift
Right.
of the jetty. It is updrift of
Right,
the jetty,
'cause the
right?
jetty changed the
I'm-
flow, right.
And I'm not sure that it's even adjacent. But, it's our position that the regulation, if it applies broadly and would say that you're required to periodically dredge to nourish downdrift and adjacent beaches. And so what the Superior Court correctly found was that we're not going to look at any one particular dredge project and say that that project violates the regulation. Rather, it's just that at some point, the town has to periodically comply. And it's our position that the record demonstrates that if the regulation is applicable, the town periodically complied. Not only has it provided nourishment to Miramar Beach in the past, its 10-year dredge plan demonstrates that going forward, it's going to continue to dredge the river, and it's going to continue to provide nourishment to downdrift beaches.
Was that conceded below that the public beach is not adjacent?
I don't know if that was an issue below. I don't think the town disputed that the West Dennis Beach would not be considered a downdrift or adjacent beach.
If I'm correct, 1027 has a preface that it applies only when a coastal beach is determined to be significant to storm damage prevention, flood control, or protection of wildlife habitat. Is it your view that Miramar Beach fits any of those characteristics?
It's my view, Your Honor, that that determination had to be made by the permit granting authorities in the 1990s when the jetty project was constructed. And there's no evidence in the record to show that those findings were made.
Okay, and if it turns out that that is a determination which a court can make today, is it your view that it would fit any of those criteria?
I don't think the record has sufficient evidence to support a finding that Miramar Beach fits that criteria. Okay. Yes, it's a coastal beach, but we haven't had any argument or evidence concerning its significance to storm damage prevention, flood control, or the protection of wildlife habitat. There's simply no evidence in the record as to any of those issues.
I sort of have a big picture question, because I think one of your arguments is that the Superior Court is substituting its judgment for the town. So if you assume that there is some damage to the environment, and the statute 214, Section 7A, requires that the town do something to protect the environment in this situation, without a decision by the Superior Court in this context, what guides the town in deciding whether they're going to re-nourish these 19 beaches for the next 8 years and not do anything at Miramar Beach? How does that happen if there's no guidance from the court?
So the guidance comes from, so the town in the first instance is has the expertise to determine, how to allocate its limited resources and, what the environmental needs of the town are and how to best, use those resources to satisfy those environmental needs. The second level then occurs with the extensive amount of permitting that these projects have to go through. They're not only permitted at the local level by the Conservation Commission, but the Executive Office of Environmental Affairs reviews it, the Department of Environmental Protection, Division of Marine Fisheries, the Army Corps of Engineers, other federal environmental agencies. There's a broad range of permitting and review. All of that review includes opportunities for public comment and expert opinion. And at the end of the day, all of these agencies have to come together and recognize, okay, we have 19 public beaches, 4.5 miles of seashore that we have to deal with, and we have a limited amount of sand, a limited amount of money. How do we prioritize those resources to benefit the environment as a whole to the best that we can? And that's why, we talk about in our brief that 214.7A, it's an equity statute, and equity requires balance. And
Yeah,
so,
but the problem is, the environmental agencies, they're very specific, usually of what they want you to do. So, you've got orders of conditions saying you gotta dump stuff here or there. This one's kind of odd, because it references the comments of his clients, but it then doesn't say what you're supposed to do about it, right? In the 2014 permit.
that's correct. The comments are referenced, and, the court, acknowledged that the residents of Miramar Beach were requesting nourishment, and DEP commented that, if the town were to consider that, it would have to comply with DEP's dredge regulations, which require it to give priority to public beaches first, but that if the town was going to nourish Miramar Beach, it would either have to do that with the appropriate access agreements, or that nourishment could be done with private funds.
But I take it, DEP is presented with this precise issue, aren't they? It's not, but they kind of duck it, right? It just seems odd, this whole thing. Normally you've got, as Justice Budd was asking, you've got an order of conditions that say, you gotta do this. But we don't have the 1990 decision at all. By the way, do we even have anything from the opposing experts that's saying that the 1990 edition causes this problem as opposed to the original 1935? Because I started reading the expert report. It seems like it all connects back to the original construction. There's no attempt to distinguish what happened in 1990 from 1935. Is there? Is there something in the record that does that?
No, Your Honor. And in fact, there's a passing reference in the record to the fact that the actual extension of the jetty that occurred in the 1990s extended the jetty inland rather than outward. And so the reasonable way of interpreting this is that this extension wouldn't have blocked the flow of sand any more than the original jetty construction would have.
This goes alongside the river and then comes out.
That's right. So it goes alongside the river and comes out into the ocean.
Right.
But my understanding is that when the jetty was extended, it was extended landward to sort of further stabilize the bank of the river, not to affect the flow of sediment through the ocean water.
And that's in the record, or that's simply your understanding?
No, it is in the record, if you'll indulge me for one more second.
Not sure whether you made many summer visits to make sure you had your understanding of the jetty.
So on page 378 of the record, it says modifications to the jetty over the years have included lengthening in both directions. Most recently, in the early 1990s, when the jetty was extended in a northerly direction to prevent erosion of the western shoreline.
Which way is
The
northern?
northern is inland.
Northerly is inward, that's correct. And the flow of the water goes from west to east.
Okay, thank you.
Thank you, Your Honors.
Mr. Wall, good morning.
Good morning. May it please the court, my name is Brian Wall, and I represent the plaintiff appellees in this matter, which I'll refer to collectively as the association, but they are comprised of a homeowners association, approximately 30 members, and I also represent two other private clients who own adjacent beaches, which I'm going to refer to collectively as Miramar Beach. The town of Dennis is a coastal community. It has coastline both on the north and the south of facing beaches, and as a result, the town suffers from coastal erosion problems that we're all becoming familiar with, especially this time of year. All one has to do is look at the news. One of the problems that the town of Dennis has been dealing with for a very long time is the problem with the mouth of the Swanton River.
Can I just ask you to also address the same question that I asked
Certainly, Your Honor.
which is how could the judge below come to a conclusion without having the order of conditions from the 1990s or even before that?
Certainly, Your Honor. My answer to that is as follows. This action was filed to stop an impending dredge. It was filed with a verified complaint that made a number of allegations concerning the chronological history here. Those were answered by the town. The injunction was not successful, so thereafter the parties cross-moved for summary judgment. And the cross-motion for summary judgment was based upon a very lengthy statement of agreed-upon facts. And because there were cross-motions, neither party felt that there were insufficient facts or there were material facts in issue. And there are allegations in the statement, and I refer specifically to numbers 30 and numbers 32 in the record at page 123, and an argument in the memorandum, which is in the record at page 152. The entire case was whether or not this regulation applied and whether or not the regulation required periodic, well, at the time in Superior Court, we were arguing it required all dredging and spoils to go onto the Miramar Beach. The court found that it required periodic, but the whole point is
I'm sorry, but isn't that regulation for DEP or the Conservation Commission to figure out? It's not for the town to have violated it, it's for the DEP or the Conservation Commission to say, here's what you have to do to make sure that you are doing what you're supposed to do. And then you have to look at the order of conditions to see whether the town has in fact violated.
well, certainly through a permitting process, that's how it would come up, but it was not in the order of conditions that authorized the 2014 dredge. And the record is absent as far as the order of conditions. But to answer your first question, the reason why the order is not there is that the plaintiffs did not feel it was necessary, since there were agreements on the facts that the town lengthened and repaired the jetty back in 1990.
But doesn't the lawsuit center around whether or not the regulations apply to the 2014 dredging? And the remedy seems to be fashioned based upon some alleged breach of the 1990s.
So the way that I would answer that, Your Honor, is the following, that wetlands permits have a lifespan and they expire. There's a footnote in the brief. Permits for maintenance dredging last longer than the traditional 3 years that an order of conditions typically lasts, but even maintenance dredging permits have a lifespan. And what happened in this particular case is the permits from 1990 that authorized all of that work long expired.
Sure.
And the town refiled for permits. And as an aside, the reason why one of the arguments from the town is that my clients failed to appeal any of those. They didn't receive notice. They're not abutters that receive certified notice, so they were frankly unaware of it. But to answer your question, yes, the focus of the summary judgment arguments were on the dredging that occurred in 2014 and the future dredging, because the argument that my clients have is that the work that was done in 1990, basically when the town stepped in and decided to try to ameliorate the issues that were going on in Swan Pond River, the town became involved. The town modified that jetty. The regulation that we're talking about therefore created an affirmative and ongoing obligation on the town's part. And back in 1996, when the work was done, the town fulfilled its obligations and complied with that performance standard because the dredge spoils from that dredge were in fact put on Miramar Beach. It was the dredge in 2010 that changed that. The town took the spoils and put it on an updrift beach about a mile away to protect a town-owned parking lot. That's when my clients became aware of this, and then they started to monitor what was happening at Town Hall. And when they became aware of the dredge plan for 2014, they initiated, well, there were, outside of the record, there were communications with the town as well to try to work this out, but they didn't succeed. So they looked at the dredging occurring in 2014 and commenced this action.
But in 2014, there's no injunction. The mouth is dredged. Those spoils go to the public beach.
Correct.
Correct. Now you have a lawsuit, and the judge says, well, and the town institutes some 10-year plan, correct?
Well, the town is trying to. That hasn't been done. And it's currently actually before the Conservation Commission as we speak. And with regard to that,
But the judge has basically short-circuited that by saying my order is from now on, you better nourish Miramar.
To an extent, but not completely. We were arguing below that every dredge needed to be put on the river. The judge did not agree. The judge's order below says that the regulation requires periodic redredging. So our position now is that that's satisfactory to my clients. We would like to have that affirmed. But it provides the discretion that Mr. Corbo was arguing about, that the town does not have to put all the sand from Swan River on Miramar Beach, only some of it. And so it has discretion to use the other spoils as it determines. But specifically with regard to that 10-year dredge plan, I don't necessarily agree, my clients don't agree with the town's position that it's going to nourish downdrift or adjacent beaches, because the language is rather vague. If you look at the pleadings that went back and forth in the Superior Court, the issue was Miramar Beach downdrift or West Dennis Beach updrift. And the town took the position that it had the authority and the right to do that, and it was in fact required to by these Chapter 91 regulations. The dredge plan materials that are in the record do suggest that there are 19 beaches and that some of them are downdrift, although I would argue that I think the nearest one is about a half a mile or further away. But we're not so sure that the town will be putting the sand on any of those beaches. The record's not really clear on that.
If I can go to where you started, talking about beach erosion, and all you have to do is turn on the television, you see what's going on with the weather. There's limited amount of resources. There's a limited amount of material when there's a dredging of the river. Why isn't it the prerogative of the town to determine that they should prioritize the public beaches over a private beach?
So I have two answers to that. We don't contend that the town is not required to prioritize public beaches. But what we do contend is that this jetty, which the town modified in the 1990s, to kind of put it in the vernacular, in for a pound, in for a penny, in for a pound, they stepped up to the plate to try to address those problems. It's undisputed in this record that this jetty is interfering with the natural littoral transmission of sand along the coast, and therefore this regulation recognizes that when there is that interference with the natural process, there is going to be erosion on the downdrift beach. So again, in the vernacular, the town kind of owns a problem here, and it has to comply with the regulations and put, according to the Superior Court, at least some of the sand on Miramar Beach.
If we agree, how do we quantify that in a decision?
I don't know if you need to. That was one of the things, obviously, that when we read the decision from the Superior Court, my clients are very curious as to how this is going to be implemented in the future. I think that there's some wiggle room on both sides. The town, how do we determine what is periodic? But I would make the argument that the purpose of this regulation is to ensure that the downdrift beaches are not starved of sediment. That's the language in the regulation. So the regulation recognizes that when there's a jetty like this that interferes with natural resources, there will be erosion, and that the regulation is supposed to ameliorate that.
Does that make the court in for a dime, in for a dollar? So now the court's gonna decide when the spoils go to the private beach as well?
I'm not, certainly, Your Honor, and I suppose with inflation that would be beneficial to my clients. But my clients right now are very satisfied with the outcome of the Superior Court that requires the town to do periodic dredging and placement. I think that that's something that will have to bear out in the future, how that gets worked out in practice. You can look from the record here. The dredging was in 1996. The next dredging was in 2010.
And did the expert report say it was the 1990 change that caused the change in flow versus whoever did it? It could have been private parties in the 1930s.
The expert report says that when the jetty first went in the 1930s, that it changed the dynamics, and that's when the problem began. The expert also goes on to say that the problem is a difficult one because the jetty is interfering with things. In the town, when they did the modifications in the 1990s, the expert concluded that the regulation applied. And that goes to another question that Justice Lowry asked Mr. Corbo. I'm sorry, maybe it was Justice Gant.
So the expert, who's not a lawyer, made a determination that the regulation applies to the maintenance thing in 1990. That's And that's not gonna be helpful, right?
Uh,
The expert doesn't do what he's actually expert at, which is say that the 1990 change is what caused anything, right? Because I did read the report quickly. He doesn't do that, does he?
No, he does not, Your Honor, but what he does conclude is that the jetty itself is causing the problem.
He clearly does that, and he sort of describes the problem as basically going on since the 30s.
Correct, yes.
But it just seems tricky, and I just looked at your citations. We don't have anything, whatever happened in 1990 is a legal document, and we could take judicial notice of it, but we don't have it. It doesn't, we're talking about something, we have no idea whether that order said, and you should dump that sediment somewhere else. We don't know that, right? We have no idea.
No, we don't, but what we do have, again, it's undisputed, and there are statements of material fact that were agreed upon in this matter.
I just read the 2 citations you talk about. They don't help me any. They don't say anything about what was ordered as part of that 1990 project, right?
Agreed, but what I would submit to Your Honor is that the 2 citations that I made confirm that there was construction activity on the jetty. It's undisputed the town conducted repairs and lengthened the jetty and conducted dredging.
Your brother just told us that it's in the northerly direction.
And I don't dispute that either.
But that makes it, I've read a number of these environmental provisions where they do say if you touch something, then it opens up. But this one doesn't actually say that. You don't have anything in these, do you? Is there some part of this regulation that we should look at that says if you do a maintenance project on something that pre-existed environmental laws, then you're obligated to do blankety blank? Is there something like that in those regs?
No, and our argument is focused solely on this 10.27, and what that does say, that jetties must be constructed. And so our argument, as you heard me say, is that the town stepped into this problem for honorable and correct reasons. My clients were quite happy that the town did that in the 1990s, but they touched it and they modified it and they tried to do something about the problem. And back then, they put the spoils on Miramar Beach. The permits that authorize that have long expired. And so my argument now is that it doesn't matter.
I get that part. How about, so in 2014, DEP's got a fairly massive dredging project here. Your clients are clearly present. I take it you're present. So is this brought to the DEP's attention that this dredging material should go here, and that was a condition of the 1990 permit?
The 1990 or the 2014?
Well, when they go, in 2014, DEP clearly has a robust process about what's going to happen here. It's also clearly informed about your client's desires. Is it informed that there's a legal obligation to dump the sediment on Miramar Beach?
So the DEP was not informed. The way that this works in practice is that the permitting process starts at the Dennis Conservation Commission. Right. My clients did not receive notice, and I'm not suggesting there's anything wrong with that. They just didn't receive notice, right, and they were unaware of that. The permits all issued when my clients found out about the dredge. It was nearly happening, or had happened. I don't recall. So the process with the permitting was that my clients were not able to articulate this. The town was asking its own conservation commission for a permit, and the permit that's currently in the record for the 2014 is silent on this issue. There's no requirement that there be periodic dredging.
But DEP references your clients in its decision, doesn't it? Maybe it's on the...
I think I think you're talking about is that during the pendency of this case, while we're arguing about this 2014 dredge that had its permits, the town is engaged in the effort to obtain this 10-year permit. My clients now have counsel and an expert, so they're now watching things, and they submitted some comments on the MIPA process.
And it's in the 10-year permitting process it's the subsequent one, right?
Correct, which they don't have the permits yet, they're currently engaged in that.
I got you, so that's where it first appears.
That's where the comments are. That's the first time that my clients were able to do that, and they're currently doing it now, which is a little bit beyond the scope of this record. I see that my red light is on.
I'll give you a chance to finish up, but I'm going to ask you the same question I asked your brother, which is, I believe there's the provision in the reg which says, quote, "When a coastal beach is determined to be significant to storm damage prevention, flood control, or protection of wildlife habitat, 310 CMR 1027, 3 through 7 shall apply," and you're focusing on 1027-4. Is that a necessary condition for this reg to apply? And if so, where is the finding that your coastal beach falls within that?
Yes, Your Honor, I have an answer for this one. So, sorry, Your Honor. I was a little anxious getting up here with the snow, so I'm a little,
Just fine.
a little
Go ahead.
wired up. In any event, Your Honor, so first of all, this issue was raised for the first time on appeal. So there's no evidence that we put into the record directly on this issue because it was not challenged. There is evidence in the record in the form of our expert opinion when the expert determined that 10.274C applies. He is, as a matter of a subsidiary opinion, saying it applies because the beach is significant. So is there something in the record that says it? No, but there is this subsidiary expert opinion. This is not in my brief, but while I was preparing for this argument, I should have put this in my brief. The regulation itself, 10.27, creates a presumption of significance, and that's why the expert did not feel the need to go to the state of saying that it's significant, because anybody that practices in this wetlands field knows that wetlands resources are automatically presumed to be significant, and it's up to the permit applicant to overcome that presumption or comply with the performance standards.
Is that presumption in the regs?
Yes, Your Honor, it's in 10.27, and it's part of the, I'll give you the citation. 10. It's in the preamble, if I can just find it, Your Honor.
Well, we can find that in the CMR anyway, right?
It is in 10.272, and in the addendum to my brief, it would be on page 76, about halfway down the page, and it says that when a proposed project involves the dredging, filling, removing, or altering of a coastal beach, the issuing authority shall presume that the coastal beach is significant to the interest specified above. And the expert is familiar with these regulations and knows that it's presumed to be significant, and that therefore, when he said the regulation, in his opinion, applied.
Can I ask, I have this alarm going off in my head. This is not a coastal beach though, right?
Miramar Beach is, yes.
Okay, Miramar, okay, because,
And as is the beach where the jetty is adjacent to, it's a coastal beach.
so the river dredging doesn't, maybe I'm misremembering something. I thought there was some subtle distinction here, that the dredging is taking place
Yes.
under an ocean, not a beach, so does that provision directly apply?
So, yes, I would say that it does, Your Honor. Below, the town argued, and I think they argue in their brief still, that the actual activity being proposed now, since the jetty is now long constructed, the only activity proposed is dredging, which is affecting a resource area called land under the ocean.
Right.
And their argument is that it does not affect the coastal beach. And our response to that is that a dredging project has two parts. It has the part where you dredge the material, and it has the part where you deposit the material. And the town's project does, in fact, impact a coastal beach. It, in fact, impacts West Dennis Beach.
I'm just getting back to the chief's question in your response. Does the presumption that you just read apply, do those words apply to our situation, or do you have to sort of extend it to?
I think that they apply. I think what the town is saying is that we're only dredging the river, and you've not made any case that your beach is significant. We don't have to put the sand on your beach. Our response to that is, it is significant. It's presumed significant. The expert found it as a matter of direct and subsidiary opinion, and that the project is a two-part project, dredging and depositing, and it has to go onto the Miramar Beach at least periodically.
And although your time is up, there was one last point you were going to make, and since you drove up from the Cape to be here, we'll let you make it.
That was it, Your Honor. I wanted to address your comment about significance, so I've addressed it. Thank you.
Good. All right, thank you.
Thank you very much, Your Honors.
Good luck getting back.
Thank you.